with the John Burton Foundation. We're going to go ahead and get started. So this morning's web seminar, It's the Law, is about policy changes that impact foster youth in California. Next slide, please. Before we jump into our content for this morning, I wanted to just go over some logistical information. Most of you are probably listening in through your computers, but if you do have any problem with sound, you do have the option to listen in via telephone as well, which sometimes is a little bit better in terms of sound, and the call-in information is up there on your screen. I also wanted to let everybody know that all of the materials from this morning's web seminar, as well as a recording of the audio, will be posted on the California College Pathways website, and the address is listed there on the screen, cacollegepathways.org. Finally, I wanted to let you know about our questions panel. So on the control panel on your screen, there's a box that allows you to submit questions. You can type in a question at any point during the web seminar, and if you have a technical or logistical question, we'll go ahead and try to respond to you right away. If you have a content question, we will be doing questions and answers with all of our panelists at the very end of the web seminar, but feel free to go ahead and submit your questions as they come up as we go through the material, and then we'll do our best to get to as many questions as we can after the panelists present their information. Next slide. So I am incredibly excited today to tell you about our panel. We've got all kinds of wonderful folks with us this morning who very graciously agreed to share their time and expertise with us to let us know about all of the various bills that impact foster youth that have made their way through this most recent legislative session. We've got David Estep from the Children's Law Center of California, Susanna Niffen from Children Now, Amy Lemley with the John Burton Foundation, Martha Matthews with Public Counsel, myself, Debbie Rauscher, also with the John Burton Foundation, Angie Schwartz with the Alliance for Children's Rights, and Kyle Sporliter with the California Youth Connection. So thank you all for being here this morning. And with that, I'm going to turn it over to our first panelist, Amy Lemley with the John Burton Foundation.
Good morning, everyone, and thank you again for being on today's call. We thought we'd start before we jumped into the substance of the bills we'll be featuring is do a very short summary of the legislative session. And so what you have before you is kind of a summary of the child welfare legislative season, our stats as we could consider them. And we had basically 72 child welfare bills that were introduced this session. And child welfare is in quotes because when you think about that term writ large, a tremendous number of things could fall under that umbrella. But these 72 bills are really things that speak quite specifically to either child abuse, foster care, placement, the rights of parents, the rights of children in the dependency system, a little bit on some education and truancy issues, probation, youth, probation, foster youth. And so it's a bit more of an art than a science exactly what's included, but that's the list of bills that we've all been following. And of those, 43 passed out of the legislature and a full 38 were signed by the governor. And so that's 59% that made it out of the legislature, which, it being October and being baseball season, my husband tells me that'd be like hitting 590, which I guess is pretty good. So I think it's really a sign that we do have a legislature that's very concerned about the needs of children and youth in foster care. They're pursuing policy changes, and a very healthy proportion of those made it across the finish line. Unfortunately, we don't have time to talk about all 38. We're going to focus on about 16. But before we do that, we're going to break it down by our house, by the two houses of the legislature. Next slide, please. So here you have the Assembly on the top and the Senate on the bottom. What's kind of interesting to me, so there are 80 members in the Assembly, 40 in the Senate. They each introduced the exact proportion of bills based on their membership. So because there are more members of the Assembly, obviously there were more child welfare bills introduced. But based on their level of membership, it was identical. In the Assembly, 24 of the 48 passed out of the legislature for exactly a 50% rate of passage, and 22 of those 24 were signed by the governor. On the Senate side, 19 out of 24 were passed by the legislature, so a notably higher passage rate. And then 16 of those were signed by the governor, so slightly lower, but still, what you can really see is if you can get it all the way through the legislature, things are looking pretty good in terms of the governor's signature. And to contextualize this in terms of all of the bills that go through our legislature, you can see on the bottom over 1,000 bills were passed by the legislature. So, all of the stuff that is pumping through all of those committees, all the analysis, the people running through the Capitol, that's all around, not just those bills, many others were not. And then 143 of those 1,074 bills were vetoed. So again, unfortunately, we don't have time to talk about all 38, but we are going to talk about, it's really, some slides are combining bills, but really about 16. And to begin that process, I'm going to turn it over to Martha Matthews from Public Counsel.
Hi, this is Martha Matthews. Next slide, please. And I'm going to talk about first two bills. This one I'm going to spend a little bit more time on. As you can see from the list of sponsors and supporters, this was a major group effort by a bunch of our organizations statewide. And all of us through the years had been frustrated with situations where we represented a youth who is in foster care. The youth is placed in a group home. The youth gets in a fight with another teenager over somebody's cell phone or throws a chair at a staff member in a moment of frustration. And, if this youth was at home with their parents, they would probably get grounded or get their cell phone taken away. But in some congregate care facilities, what happens is, oh, you just committed an assault and battery. I'm going to call the police, and I'm going to ask the police to file charges. And so just by virtue of their living situation, we were seeing youth taking steps towards the criminal justice system for behavior that it's not great behavior, but it is typical of things that teenagers do. So that was the core of the bill, and then along with that, we also addressed a couple other issues. For example, if the police do get called for a foster youth and the youth gets taken to juvenile hall, again, if that youth had a parent, the parent would probably be in the lobby in juvenile hall begging for the child's release at 2 o'clock in the morning, the kind of thing that as a parent you dread, but it may happen. If you're a foster youth, no one is clamoring for your release in the middle of the night. And so foster youth are much more likely to be detained in juvenile hall pending adjudication, even if, according to the probation department's analysis of flight risk or risk to the community, they would be eligible for release. So, they not only get arrested and charged more often, but they also get detained in juvenile halls in conditions where someone who wasn't in foster care wouldn't get detained. And then the last part of the bill is the legislature really enjoys being tough on crime, and one of the kinds of legislation that's quite popular is making criminals pay for their crimes, which sounds great. But the way that works for a foster youth is, let's say a foster youth throws that chair in a group home and it breaks a window. And so not only are they charged and adjudicated, but they are assessed restitution for the cost of the broken window, and then there's a fine tacked on top of the restitution. And so all of a sudden that youth is looking at sometimes thousands of dollars. Meanwhile, the group home just submits a claim to their insurance and gets the window fixed. So another issue the bill addresses is excessive fines and restitution that foster youth have no means to pay. So you can see the solutions on the slide. They're not radical, but they're something. More involvement of licensing for group homes that have very high rates of calls to law enforcement, and it is up to the agency to figure out what that means through rulemaking. A work group to develop performance standards and outcome measures about how group homes what they're supposed to do instead of calling the police all the time, because well-managed group homes don't call the police all the time. They have their own behavior management systems. and then exempting foster youth from restitution fines and limiting restitution to actual out-of-pocket costs not covered by insurance, and also instructing judges that a foster youth status is not a reason to detain them pending trial when they would otherwise be released. So then you can see, obviously, our job next, the advocates who got the bill passed, and any of you who want to help, will be to work with the state agency to implement the parts of the bill that involve community care licensing and a work group, and to get the word out to judges, public defenders, and minors counsel. So that's AB 388. Next slide, please. AB 2276 addresses kind of a related problem, which is that often juvenile justice youth, especially youth who are coming out of juvenile hall or probation camp, have a really hard time getting reconnected to school, and that moment of transition from juvenile justice involvement, whether it's a very short stay in juvenile hall or it's a long stay in camp, that can be a moment where people sort of fall off the rails and never do get back into school. And then that triggers dropout rates, which trigger long-term poverty, and then because attending school is a condition of your probation, then you get a probation violation, and then you go back to jail. I mean, it feeds into the sort of negative cycle. So AB 2276 extends the same immediate enrollment rights that foster youth have now to all youth who have had contact with the juvenile justice system, and that's deliberately very broad. It covers everyone who is arrested and detained for a day or two to someone who's coming out of camp after a 12-month commitment. So it's everyone who's touched the juvenile justice system and then needs to come and re-enroll in school has a right to immediate enrollment, just like a foster youth does. And it requires county offices of education and probation departments in each county to create a transition plan for these youth. And then similar to 388, a statewide work group on best practices for enrollment and re-engagement of these youth in school. So similar implementation factors, obviously now we all have a job to do to figure out how to make this actually happen. So that's my 5 minutes on these bills, and I will now pass it on to the next speaker, who I believe is David Estep from CLC.
Thank you, Martha. Yes, this is David Estep from the Children's Law Center of California. I'm going to start with AB 1761, which is really meant to strengthen the relative placement provisions in 309 and 361.3. One of the things that we often see in the early stages of dependency cases is that when a petition has been filed and it's come to court and the child is not yet with a relative, the child welfare agencies will often wait until the court acts to find a relative or place. And what the AB 1761 is really meant to do is really meant to encourage the continued search and approval of relative placements so that we can get kids into these homes as quickly as possible. Section 309, there's been language added to Section 309 that allows for these temporary placements up to the dispositional hearing to really emphasize that the child welfare agencies do have the authority and should continue to look for relative placements up to the disposition. And also what's happened is that that we want to keep the process continuing when there are multiple relatives. Sometimes we have situations where child welfare agencies have 2 or 3 or more families that they may be considering, and rather than deciding to pick one of those, they wait and let the court decide, which means that the child remains in foster care for an unnecessarily long period while they're waiting to decide which of these multiple families may be the best. And so this is really meant to encourage the department to take action to place with an approved family as soon as it's approved, even if there may be other families who could be as approved as well. So this is really meant to encourage early placement and prompt placement, and to make it clear to child welfare agencies that they do have that authority, even if the petition has been filed and we're awaiting disposition. There is one additional technical change that AB 1761 includes although it is technical, it's relatively significant. In 361.3, the current language relating to relating to the placement of siblings and half siblings states that they're supposed to consider placement where it's in the best interest of the child. And what the amendment to 361.3, what it does is it really emphasizes, it sort of switches that burden so that unless the placement is contrary to the safety and well-being of any of the siblings, they're really supposed to be placed together. So we're really trying to strengthen the sibling placement preference as well. So this is really, 1761 is really about the family. It's not only about trying to place with relatives, but also strengthening the efforts to place siblings together. And so if we can have the next slide. And the next bill is AB 2668, which is really meant to provide support for non-minor dependents who are parenting their children on their own. Currently, when we have teen parents who have children who are not detained, and the children are, and the teen parent is living in a foster care setting, the teen parent and the foster parent can develop what's called a shared responsibility plan. And in that plan, it provides support, mentorship for the teen parent, and there's also a financial payment of $200 a month that can go to the teen parent to help support the child in the foster home. And this is really meant to sort of clarify the responsibilities of the teen parent and the foster parent with regard to the non-detained child, the baby of that teen parent. What AB 2668 does is it really tries to expand that for non-minor dependents who aren't living in foster homes, but who are out in the community living in supervised independent living placements. And the idea is that the non-minor dependent parent will try to identify a responsible adult who they can sort of develop this plan with, this mentorship plan, so that they will create a plan similar to the plan that we use for teen parents, and then they will be able to work with the responsible adult to provide support to the teen parent and to the child in the home, and that this will allow for a much stronger relationship in the non-minor dependent parent's home, to hopefully avoid problems which can occur because a lot of these young parents end up on their own, and especially with the non-minor dependents, although they're in supervised independent living placements, if they don't have a mentor identified, that can create some difficulties. And the other advantage of this as well is that it adds in the $200 that the teen parent can get, the non-minor dependent can get that $200 as well once that plan is created. And the plan, the way it's supposed to work, is that the non-minor dependent, the identified responsible adult, and the social worker who's working with the family, with the non-minor dependent, can create this plan together to try to come up with what services and programs and assistance the non-minor dependent needs to make sure that the placement, the child's continued placement in that home is successful. And I guess I'm going to now turn it over to Angie Schwartz.
Thank you. Hi, this is Angie Schwartz. I'm with the Alliance for Children's Rights, and the first bill I'm going to discuss is AB 2454, which was attempting to address the issue of former foster youth who either entered guardianship or adoption, and then after the age of 18, that guardianship or adoption disrupts, and that individual stops providing support to the young person. And that was something that we were seeing in our own cases in Los Angeles County. And there was no way for those young people to re-enter foster care because, of course, prior to this, the requirement was that the youth have an order for foster care on their 18th birthday, and then there had also been legislation that allowed a youth to reenter if the adoptive parent or the guardian had died, but nothing to address this particular issue. And so AB 2454 attempts to solve that issue by allowing these youth who have that disruption in the adoption and the guardianship to also reenter, as long as they meet the following criteria. They have to have been receiving assistance through KINGAP or through the non-related legal guardian program or through the adoption assistance program after the age of 18. And then their former guardian or adoptive parent has to no longer be providing support, and the payments have to have been terminated. And the youth has to be under the age of 21, because obviously the assistance would still stop at the age of 21. And there has to be a finding by the court that that reentry is in the non-minor's best interest. And then they, of course, have to meet one of the 5 participation conditions. And so we're actually going to be running a cleanup bill this next year to try to continue to smooth this process out. The couple issues that are going to be factors in implementation this year have to do with the fact that the benefits have to have terminated prior to the young person being allowed to reenter. That is an issue that we're probably going to be addressing in cleanup, at least for this next year. Benefits have to have actually stopped, which means that for those that advocate for these youth, it may involve, some contact with the county and saying, the money's not actually being used anymore to support the young person, and actually get the county to terminate the assistance so the young person can re-enter. So that's probably the biggest issue I see, and again, one that we'll be working on in cleanup this next year. So next slide. The next bill, AB 1089, has to do with foster youth who are also regional center clients. So regional centers serve youth with developmental disabilities in our state, and so foster youth for regional center clients, we're having trouble having continuity with those regional center services. It can be really very important for the young person's placement stability and also their ongoing development and support. And when they moved foster homes, sometimes the transfer of the case between the regional centers wasn't happening, and we had youth in our own caseloads that had gone many, many months and actually upwards of a year without the regional center services being initiated by the new regional center. So this legislation was an attempt to address that problem, and what it does is institute timelines in order to make sure that the cases are transferred in a timely manner. So it requires the county social worker or probation officer to immediately send a notice of relocation at the point that to the sending regional center at the point that they know that this young person is going to be moving foster placement. And then once that sending regional center has that notice of relocation, then they have to go ahead and immediately notify the new regional center where the youth will be living that this case is being transferred, and then ultimately all services have to be in place and a new ITP has to be in place. An ITP is individual program plan. That has to be in place within 30 days of the young person relocating. So there's some more nuances to the timelines, but that's kind of a really basic overview of the timelines that are now in place to try to make sure that we're going to be transferring these cases in a more timely manner. And I think the biggest implementation issue is going to be training social workers and also regional center staff about the new protocols and about the timelines, and just making sure that procedures are put in place to comply with these new timelines. So now I'm going to be turning it over to Kyle with CYC.
Great, thank you, Angie.
Well, actually, I think me at this. Oh no, I'm sorry.
Nope,
sorry.
I think we're at me. This is Kyle Sporleader with the California Youth Connection, and I'm very pleased to be presenting Senate Bill 1099, which Senator Steinberg very graciously authored for us this year. For those folks on the webinar who are not very familiar with CYC, what we try to do every year is survey our entire statewide membership, which is current and former foster youth, and have them identify what they feel the most salient issues in the foster care system are for that given year. And so it was a surprise to many of us to hear that this past year sibling visitation was that kind of hot button issue for our members that they really felt like needed to be addressed legislatively. I think it was particularly surprising because of all of the existing protections in statute, many of which were put there by a prior CYC-sponsored bill about 15 years prior. And so when we looked at this, we decided that since our members who are current and former foster youth were saying that sibling visitation is still an issue despite these protections, we thought that was clearly indicative that there were some gaps in the existing statute. And so we went back through the statute and we consulted with dependency attorneys that we partnered with on this legislation and tried to decide what areas of statute could we address and help strengthen the existing sibling visitation protections, but also expand sibling visitation so that our members could feel like we had made some type of difference in helping them see their siblings who were in and out of care. And so some of the things that we did to really strengthen and expand sibling visitation protections were, one, we decided that there needed to be greater detail in the section of court reports for these periodic review hearings that foster youth and non-minor dependents have, where they talk about what sibling visitation is happening if siblings exist. And so right now in the statute, at least before SB 1099 was signed by the governor, all that was needed in those sections was a description of the nature and frequency of sibling visitation. When we consulted with some of the dependency attorneys who are working with many of these youth in these sibling visitation situations, they felt very strongly that they needed more information to be able to understand what sibling visitation is looking like. And so some of the things that we wanted to include in the new court reports is a description of whether or not these sibling visitations are happening supervised or unsupervised. If they are being supervised, a discussion of why they're being supervised and if there's any plans to make them unsupervised. And also a description of the location and length of any of the visits, because we are hearing very often from our members that even when sibling visitation was happening, it wasn't natural. There were obstacles to it. There were things that were making the sibling visitation awkward for them, and that was putting more of a strain on the relationship with their siblings rather than helping them maintain and develop those relationships as the original legislation definitely intended. Another thing that our bill does is it requires the court to make a renewed finding at those periodic review hearings when sibling visitation has been suspended. And this came from, again, our members saying that sometimes, especially when they entered foster care, if they were separated from their siblings, they were not only dealing with the initial trauma that led them to foster care, as well as the trauma of even entering the system, but a lot of those circumstances sometimes combined to cause different types of behavioral issues in these members. Some of these foster youth were dealing with anger management issues, and because of issues like that, the court found that maybe there was some concerns about safety between the siblings, and so sibling visitation was at least supposed to be temporarily suspended. Well, we were finding from our members that even after that initial suspension of sibling visitation, that suspension was never being looked at again. And although existing statute prior to our bill did say that those decisions need to be reviewed, we felt that it could be tightened up by asking the court to officially make a finding at each of those 6-month review hearings so that there was a look back at the evidence and seeing if it was still relevant and if it still determined that there was those concerns about safety for the siblings to visit one another. Another thing that our bill does is that it allows foster youth and non-minor dependents to request a visitation with siblings of theirs who are not dependents and not in the system, but who are currently in the physical custody of a shared parent. And so this came up from a couple of our members, but as folks who maybe work in this field will realize, these are cases that are rare, and albeit rare, they are still significant. And so one of the cases that we were looking at when we decided to put this into our bill was a young man had been taken out of his home because it was found that his biological mother was abusing him, both physically and mentally. His biological mother also had another child by another person, so that was not a sibling of his by blood. But in California, you can also have a sibling is much more widely defined. Well, this young man felt that it was very unfair that he couldn't have visitation with that sibling who he definitely had a relationship with, but under the current statute had no right to visit that sibling because that sibling had never been put into care. And for many of us, it's shocking that if a parent has one of their children being put into care and there's been findings of abuse, that they would still have the custody of another child. And so again, although these situations may be rare, it's definitely significant when it does happen. And we wanted to make sure that there was no gray areas and that these kind of situations weren't overlooked for when there were siblings who ended up in foster care but still had siblings who were no longer in foster care and wanted to visit with those siblings. So those are some of the things that our bill does. As Debbie mentioned before, I'm sure there's a Q&A section later on, but right now I believe I am passing it on back to Amy with the John Burton Foundation.
Thanks, Kyle, very much. Next slide, please. Okay, I'm going to talk about two bills. The first one is SB 1023. We are really appreciated Senator Carol Liu, who authored this bill and did a tremendous amount of work to make it successful each step along the way. The issue that SB 1023 is working to address is really the low rates of educational attainment among foster youth and community college in California. I think we've all seen over the last 10 years, we're beginning to deepen our appreciation that education is squarely part of the well-being of children, and yet that kind of awareness often falls off after K-12. And so with extended foster care now resulting in most young people extending till age 21, really trying to think about how can we not just stop at high school graduation, but help young people make a strong, seamless, supported transition into community college. We know from the research that less than half of young people who enter a community college who are foster youth will return the second year. So there's a tremendous drop-off rate. And so this bill was really intended to ensure that if a young person arrives at a community college campus, how can we really connect them with the resources, support, the academic counseling that's going to help a foster youth in particular succeed. This bill was really the product of over a decade of efforts around the state. Tremendously innovative people on community college campuses, CSUs and UCs, as well as private campuses, who have been really honing the approach and saying, what is the right combination of academic support and social support? What is the recipe to ensure that young people succeed on community college campuses? And so what SB 1023 will do is authorize the Community College Chancellor's Office to provide up to 10 community college districts to apply for funding to establish programs for foster youth as part of the existing EOPS program, Extended Opportunity Programs and Services. I'm sure many of you are very familiar with EOPS, which is a fabulous program that is in place on all of community college campuses in California. It's also an evidence-based program. It's been shown to measurably improve the retention and graduation rate of students who participate. So what SB 1023 will do will really to be create a program under the umbrella of EOPS in a similar fashion to CARE. For those of you who are familiar with CARE, CARE is also another program which is under the EOPS umbrella that addresses the needs of students who are receiving CalWORKs. And so we are very excited to see how this moves forward. What I want to say is we often get questions that says 10 community college districts. Some districts have more than one school per district. Many only have one school, but it is 10 community college districts. So a few factors in the implementation clearly is, really figuring out the funding for the bill, along with the process to allocate the funding. That really is in the hands of the California Community College Chancellor's Office, who was formally in support of the bill, something that made a tremendous difference in its success. And so they will be the entity that will determine kind of what the criteria are, and to really administer that process. So that is SB 1023. Moving on to SB 1252. Next slide, please. This is addressing the needs of young people who participate in THP+. This is a program in California that's available for former foster youth age 18 to 24. Now, some of you may be thinking, why would anyone be 18 and be in this program? As we all know, some young people do not opt to participate into extended foster care, and some young people are not eligible. They don't meet one of the 5 participation conditions. And so this is a program that's for former foster youth previously age 18 to 24. And what we are hearing from providers is that the 24-month time period often cut young people off right at that moment when they were maybe 1 semester away from getting that associate's degree. And so what SB 1252 does is it provides the option for counties to slightly change the eligibility criteria for THP+. Specifically, it allows young people who are enrolled in school or vocational education to participate in THP+ for 36 months, which is 12 months longer than the current limit of 24 months. And it also allows the upper age limit to go to age 25 instead of the current age limit to 24. So again, this is an option taken by counties. And so in terms of factors and implementation, CDSS will likely issue some kind of all-county letter, specifying the process of how a county would opt into these provisions. We can imagine that would be how things would go moving forward. And this would become effective as all the other provisions we're talking about in January of 2015. Sorry about that, the date on the slide is incorrect. So thank you very much, and I'm going to turn it over to Susanna Niffen of Children Now.
There were actually some exciting things that happened in the budget this year for foster youth. The legislature actually approved almost $40 million in new money for programs to support foster children, which was pretty amazing. One of the first things that they did was they approved the Approved Relative Caregiver Funding Option Program, which is perhaps one of the worst names we've ever had for a program, and we're now calling it the ARC program, A-R-C. What this program does is it provides counties with the option to collect $30+ million to provide state foster care funding to foster children who are being raised by relatives who currently only receive CalWORKs benefits. So currently a foster child who is placed with a relative often receives much less than the traditional foster care payment, although it costs the same amount to raise a child whether you're with a relative or not. Many relatives are below the poverty level, struggling. Many grandparents take in their grandchildren, so they're on fixed incomes, or aunts and uncles who already have several of their own children are being asked to take in sibling groups of 3+ children, which is a real strain on budgets. And so what this will do is allow counties to opt in and provide the same amount of funding for children with relatives as opposed to children who are in foster homes. It's a really big change, and it is going to really help stabilize relative placements, which, as we all know, are the state's priority and where foster children tend to do best. I just want to say a quick thank you to the Alliance for Children's Rights and the Step Up Coalition for really spearheading this issue and getting it through. Another big program that was approved through the budget was a program, it was $5 million this year, to train county workers to identify, intervene, and provide services to CSEC victims. These are the commercially sexually exploited children, and to develop protocols for how to deal with CSEC victims within the child welfare system. This has been a struggle for counties, as these youth tend to have some different problems and issues than other foster youth. So this money is out there to help counties figure out how they're going to help these youth, and in ongoing years, the legislature has approved $14 million a year for counties to provide prevention and intervention services for CSEC youth. So that was another really big change in the budget. A couple of smaller changes. One, the budget directs the Department of Social Services to track social worker caseloads so that we have a better sense of how high caseloads are and if they're anywhere near what they should be, to allow social workers to be able to do their jobs appropriately. And another item that was passed was has to do with group home staffing, and it states that group homes may no longer employ those who are under the age of 21 to work with foster youth. And this was to address a problem that many foster youth have talked about, that while they're in group homes, sometimes their staff are only a year older than them, and it can be very tricky for them to relate to someone who's their own age as an authority figure. So this is an attempt to address that. Some of the factors in implementation around the ARC program, the Relative Caregiver Program, counties have to opt in to this program. The original opt-in date was October 1st of this year. However, the state had some problems kind of determining what a base caseload would be, and so how much money would be distributed to the counties that opt in and how that money would be distributed to the counties. So they've kind of created a workaround and pushed back that opt-in date for the counties until they can give the counties more details about the funding. We'll move on now to SB 873. SB 873 was also part of the budget. However, usually the budget, there is a bill passed in the summer, which is the main budget bill, and then there's usually a cleanup bill towards the end of session where you can kind of clean up some issues from the budget, or if there were items that were left off, they can be added. One of the things that was added in the final budget bill, which is SB 873, provides due process protections for unaccompanied juvenile immigrants. As we all have heard in the news, I'm sure more than 60,000 unaccompanied minors have been entering the United States fleeing violence and poverty in other countries. And how to deal with these unaccompanied minor immigrants has been something that we're wrestling with as a state and as a country. Here in California, we put together a package of $3 million for the Department of Social Services to contract with nonprofit legal services organizations to provide culturally and linguistically appropriate legal services to these unaccompanied, undocumented minors who are seeking special immigrant juvenile status. And while it was a nice first step, I think everyone working on this issue recognizes that it's not nearly enough and that it doesn't truly meet the need, and so I'm sure we'll be seeing more on this issue going forward. And now I'd like to pass it to Debbie Rauscher.
Hi, thank you very much. So I'm going to talk about a couple of bills specifically related to post-secondary education. The first is SB 860, which is the trailer bill to the budget specifically that addressed issues related to education. And the significant piece in SB 860 has to do with something called student equity planning. So at the community college level, the state allocated $70 million to community colleges to implement student equity plans. And student equity plans, each district, each campus actually has to create a plan where they do research and look at data to identify particular subpopulations that have disparate impacts, so that aren't doing as well in college as the general student population. And so prior to SB 860, the populations that had to be addressed in equity planning included different racial and ethnic groups, different gender groups, students with disabilities, and there were some additional populations added, including foster youth. And so this was actually a really huge accomplishment to have foster youth be included in the equity planning. So now each community college campus has to look at how their foster youth are doing, and if foster youth are not doing as well as the general student population, they have to identify specific steps that they're going to take to try to improve outcomes. And they'll be able to use a portion of this $70 million that's been allocated for all of equity plans to implement these activities specifically for foster youth. Next slide. The next post-secondary education related bill that I wanted to address is AB 2160, which has to do with Cal Grants. So folks may be aware that Cal Grants are the financial aid that's available to students in California who are participating in various forms of post-secondary education. And in order to receive a Cal Grant, a student has to submit verification of their high school GPA. And in some cases, high schools were failing to provide that information. And if the high school didn't provide the GPA information, then the student was not able to get the Cal Grant due to no fault of their own. And there's research that has shown that when districts pilot the use of electronic submission of GPA verification, there's been a 15% increase in the number of students who actually are able to get Cal Grants. So AB 2160 makes electronic submission of GPA information from high schools mandatory. So all public high schools, including charter schools, have to submit the GPAs for all of their high school seniors to CSAC, the Student Aid Commission, so that that information is automatically available for all students, and students no longer have to go through fights with their high school campus to get their GPA information submitted if that campus hasn't done it already. There is also an opt-out process so that if somebody doesn't want their GPA information submitted, they can opt out so that information doesn't get submitted to CSAC. Next slide. And the last post-secondary education bill that I want to address is around the Cal Grant B award. And so this is the award that provides funding for books and living expenses for students, and it's currently set at $1,473 a year. And so over time, the value of this has really gone down significantly due to inflation. And so it has lost a lot of its purchasing power over time, and is really inadequate for students to actually be able to cover their costs while they're attending college. So the idea with these two bills is to be able to increase the amount of money that's available through the Cal Grant B. And I'm not going to go into the details of how this is set up. It's sort of a complicated financing mechanism that the state has chosen to use, where they're going to sell tax credits and use the income generated to pay for the Cal Grant increase. The bottom line is, because of this complicated financing mechanism, there's not a fixed amount that Cal Grants are going to go up by. They could go up to $5,000 a year. That's the maximum. But the actual amount that they go up is going to be dependent on how many of these tax credits get sold. So the expectation is that the Cal Grant will probably go up to about $3,000 a year. This is the Cal Grant B specifically. But it remains to be seen exactly how much. But there definitely should be some increase to the Cal Grant B award. And pretty much all foster youth are going to be eligible for this. This is an entitlement award that's based on income, as long as the student meets the basic GPA requirements and they submit their application by the March 1st Cal Grant deadline. And so this is going to go into effect for the 15-16 academic year. Next slide, please. I'm going to touch really briefly on some bills that did not make it through the process, that were vetoed by the governor. There was a bill about human trafficking that was not successful. There was a bill related to providing vital documents to foster youth at age 16. That also didn't end up moving forward. Some sentencing enhancements related to sex trafficking, which also didn't move forward. There was a bill related to truancy tracking, which the governor vetoed because he believes that that data was already collected. And then a Pay for Success pilot program, which would have been an approach that could have potentially been required for child welfare and social service programs. But that also did not move forward. So just a little bit of a sense of some of the bills that did not survive the entire legislative process. So if we go to the next slide. We're going to go ahead and move into our Q&A now. We've gotten a lot of really great questions coming in, so thank you to everybody for all of the questions. And I'm going to kind of move through them in the order that they came in, which will sort of coincide to the order of how we presented the bills. So I'm going to start with Martha and a question about AB 388, which is the preventing the criminalization of youth in congregate care. So the first question is, when does AB 388 go into effect?
It was not an urgency measure, so I believe it goes into effect on January 1st along with everything else. But if there are people on the call that know better than me, please speak up.
Okay, great. And then a second question related to 388 is, how will the pre-trial detention and release decisions, how will those provisions be enforced?
Well, those provisions are in Welfare and Institutions Code 241.1, which generally governs the sequence of hearings and decisions for what are called crossover youth, where someone is a foster youth and then a delinquency petition is filed. And so there's a bunch of special things that are supposed to happen for these crossover youth, including a special hearing for the court to determine whether the youth should remain primarily supervised by the dependency court or whether the youth should be primarily supervised by the delinquency court. So what that part of the bill does is it inserts into 241.1 a provision that the decision whether to detain or release a foster youth who has picked up a charge is based on the same considerations as for any other person who is detained. And that's a list of factors about whether the youth is a flight risk, whether the youth is a risk to community safety. And the judge is required to make the decision based on those factors, not on whether the person is a foster youth or not. And then if the judge decides this person is eligible for release, the judge can then order the child welfare agency social worker to find a placement for the youth. Because often one of the reasons they sit in detention is the group home where the incident occurred, who called the police, doesn't want them back. And so it's actually difficult to figure out where they should go. So the statute, the new provision says the judge can order the child welfare agency to find the person a new placement. So that is part of the 241.1 process, and it is incumbent on all of us to make sure the judges and attorneys involved in that process know about this incremental change to the law and follow it.
Great, thank you. So my next question is on AB 1761. So this is about timely placement with relatives. So David, I'm going to address this question to you.
Okay.
The question is whether this means that the child welfare agency no longer has to do criminal clearances before placing with a relative under these circumstances.
I was going to say no, unfortunately it doesn't. But no, it doesn't. It doesn't change that requirement. The criminal background checks still need to take place. This is really meant to address a situation where there may be multiple placements, or at the time of the detention hearing, the department has not been able to finalize a decision as to a relative, and to let the department know that up through disposition, they still have the authority to temporarily place. Because what happens is that oftentimes we get departments that won't do anything once the detention is filed, and they expect the court then to be making the decisions. So it doesn't change the rules with regard to 361.4 for the criminal background checks. It's really meant to emphasize that the department has this continuing authority to make these temporary placements.
Great. I have a number of questions on AB 2668, the parenting youth in SILPs.
Okay.
So the first one is whether or not the $200 financial incentive that you talked about is in addition to the infant supplement.
Yeah, I believe it is an addition. Yes, it is. It is an additional, and because it's really based on the completion and implementation of the plan, the support plan.
Okay, great. And second question is, does the non-minor dependent have to have full custody of their child to get this benefit, or can it be partial custody?
Well, that's an interesting question. I don't have a definitive answer on that. I think that it would depend if the shared custody is between between a mother and father or two parents. There would probably be, I don't know. I mean, if they had primary custody, I think that it would certainly apply. If it was 50-50, I'm not sure, although it may apply. I think that may be a rule decision.
Okay. Great.
That's one that I'm not quite clear on.
Right. Okay. Thanks. And then, does the mentor or adult need to actually be living in the same home as the non-minor dependent?
No. When the non-minor dependent is in the supervised independent living placement, the idea is that they sort of have their own home, and so the idea would be is that this responsible adult is acting as a mentor, someone who's coming in to assist. So it's not that they necessarily need to be living in the home the way that the teen parent is with a foster parent. So it really is that they're still on their own, but that there is this responsible adult who is available to provide assistance and who has agreed to provide assistance, and there's been this plan developed.
Great. And Martha, do you perhaps know the answer to this question about partial custody?
This may not be a definitive answer, but the same issue came up with the infant supplement. If a mom and a dad share, and they're both non-minor dependents, and they share custody of a child, can they both get the infant supplement? CDSS said yes to that. So that makes me think, if they're sharing custody and each one of them creates this plan with their own mentor or even with the same mentor, the answer might be the same, that they would each get the $200 for creating a shared custody plan for the mentor. I'm just saying that if it would be logical for it to be the same answer as for the infant supplement, but I don't know that for sure.
Great, thank you. And then, David, do you know if there's a process for how child welfare or probation will screen the adults?
No, I think that part of this is still being worked on, so I don't think that's finalized yet.
Okay, so that'll be in the regulatory process.
Yeah.
Right. Another question is, if no other adult can be located, can the role of the adult supporting the parent be done by the social worker? Perhaps another one for the regulatory process.
Yeah, and I mean, I think that raises just some conflict questions as well. I think one of the things is that we have the non-minor dependent, the responsible adult, and the social worker. I'm not sure that it would be appropriate for the social worker to sort of pass off on their own plan, and then there might be some other conflict issues there. So I think that would probably be subject to the regulations as well.
Okay. So next up, I'm going to have some questions for Angie. So the first question is about the re-entry after guardianship. The question is, does it matter whether or not the guardianship was established before or after the age of 16?
So the statute provides that payments have to be received after the age of 18. So it's trying to allow those youth to reenter who had the expectation of payment after the age of 18. And it's not always that some youth are able to receive payments after the age of 18, even though guardianship or adoption was established before the age of 16. So that's, young people with disabilities in some instances, sometimes due to the completion rule or other things. So it was really about those youth that had the expectation of still receiving payments after the age of 18 would be able to reenter and continue to receive those payments.
Great. Another question for you on the reentry. Would a youth be able to reenter through this provision if they had gotten married?
So my understanding from DSS is that, as with all things extended foster care, if you get married before the age of 21, then your eligibility ceases, and that's the position they've taken with regard to all payments AAP can gap non-related guardianships in extended foster care. So I think that they have held firm on that position.
Okay. And then if a youth in legal guardianship wants to reenter care, who would be the best contact for them in their county?
So my sense is that because they have to have the payments, I mean, this would probably be a question for the ACL and something DSS should think about including in the ACL, but my sense is that they would want to at least start with their kin gap worker, or for non-related legal guardianships, whoever does the 6-month case plan, and for adoptions, whoever their adoption worker is, because that's the person that's going to have to make sure that, you know, the funding has terminated, which is one of the conditions of reentry. So I think that they would want to start there. I mean, these young people don't have social workers anymore, so it would make sense to start with their kin gap worker or their AAP worker or whoever their caseworker is.
Great. So the next question is for Kyle about 1099. The question is, does SB 1099 relate at all to sibling placement, or is the bill just focused on visitation?
Unfortunately, it's just focused on visitation, but working on the bill and really spending the year-long process continuing to get feedback and input from our own members, it was clear that a lot of these visitation issues and just visitation in general is something caused by the root problem of not placing enough siblings together. And so it's something we've looked at working maybe in the next couple of years, but unfortunately SB 1099 itself only deals with visitation issues.
Great. And then another question, how would a dependent youth petition for visitation with a non-dependent minor sibling when a bio parent is refusing this?
Well, there's under this new bill, they are allowed to petition regardless. It is up to the court to kind of deal with the different moving pieces there. And so if there's opposition from that shared parent, then that would be taken into account. But ultimately, it would still be up to whether or not there's a belief that the visitation is contrary to the safety and well-being of those siblings. And so the court will ultimately determine that and would obviously welcome input from that shared parent. But under this bill, that foster youth or that non-minor dependent now is able to petition for that visitation regardless, just as they are able to petition for visitation with a sibling who is in the system with them.
Great. So Amy, I've got a couple of questions on SB 1252. First question is, do you have any sense of how many counties will choose to opt in to the extended THP Plus law?
No, I don't. I think that we've seen kind of more interest in this in different parts of the state. Part of the reason that I think there was interest is a lot of the regular kind of historical participants in THP Plus opted into extended foster care. And so we saw a little underutilization of the program this year. That being said, we have almost 2,000 20-year-olds who are now in extended foster care who will be aging out in 2015. And some portion of them, namely individuals with disabilities and parenting youth, will likely need THP Plus. So I think what counties are thinking about is how much of our THP Plus do we want to make sure is there for those youth who are aging out at 21 and because of their individual circumstances may need more support, and how much of it do we want to keep, how much of it do we want to provide for this extra year of support? And I think that's a conversation that will need to happen on a very local level with providers and county administrators to think through what the needs of their individual counties are.
Great. The second question is, if a former foster youth has timed out of THP Plus and they're enrolled in school full-time, can they come back to THP Plus under this bill?
No. This provision is effective January 1st, and the eligibility is not retroactive.
Okay. So the next question is about the budget bill. So Susanna, I'm going to turn to you for this one. Somebody just wants to clarify, you said that the opt-in date for the relative caregiver part of the budget bill has been extended?
It hasn't technically been extended, and this gets a little bit confusing, but what the state has done, Department of Social Services has allowed counties to send in a non-binding intent to opt-in letter by October 1st. It's non-binding, however, because DSS has not been able to provide them with the information they need to be able to actually opt in. So while it's not technically an extension, it has, in practice, given the state a little bit more time to provide an ACL and to provide some more detail to the counties on how the financing will work with this program before they have to make a final determination.
Great. Another question is, will SB 855 have any impact on the funding for relatives who adopt foster youth?
No.
Okay. Amy, back to you with a question about SB 1023. The question is, when will the 10 districts be selected and how will they be selected?
I can tell you the process to select the districts will be determined by the California Community College Chancellor's Office, which administers EOPS. They've been extremely engaged in this and supportive of the educational needs of foster youth, so I'd be extremely surprised if they didn't solicit some input, but that is the administrative body that will determine that process. And when that will happen, I do not know. That is, that timeline will be set by the Chancellor's Office, and I'm sure that as soon as they know that they will share that. And we're in communication with them. Again, they were in support of the measure, but that information is not known at this time.
Great. I'm getting a lot of questions actually about where this information will be available. So we will be sending out the PowerPoint presentation to everybody on the call, and the recording and the slides will also be posted on the California College Pathways website, which is listed there on the slide that's on the screen right now. At the top of that page, if you go to the link that says training materials, that's where it will be, and it should be up there by the end of the week. So I have another question on SB 873. So Susanna, I believe that's you. The question is, can you clarify whether SB 873 addresses how the child welfare system will serve unaccompanied minors, specifically if they will become 300 dependents?
It does not go into that level of detail. That's one of the things I think that people are still wrestling with and will need to address next year.
Okay. And then another question on the guardianship piece. So Angie, just to clarify, if a youth's guardianship was terminated at age 18, that individual is not qualified to re-enter foster care, correct?
If the guardianship was terminated at age 18, that doesn't necessarily mean they're not qualified to reenter, because most guardianships terminate at age 18 as a matter of law. The question is whether or not they had the ability or the right to continue to receive payments after the age of 18, even though the guardianship may have terminated at age 18. And like for a non-related legal guardianship that was created in dependency court, they had the right to receive payments until 21, regardless of the age that the youth entered that guardianship. For youth in a kin gap guardianship, then they had the right to receive kin gap after the age of 18 up till 21 if the guardianship was entered after the age of 16, or if the young person had a disability that warranted the continuation of assistance. So there are lots of instances where the young person had the right to receive benefits after the age of 18, even though guardianships terminate at age 18 as a matter of law. So you really have to look at when benefits were supposed to terminate, not when the guardianship terminates.
Great. So Susanna, another question on 855, the budget. Is the money designated to supplement relatives who only receive CalWORKs optional, or are counties mandated to supplement all of these relative caregiver payments?
It's optional. So counties have to opt into the program. Under realignment, what we found is that it's very difficult now for the state to be able to direct the counties to do any new programming. And so what we've seen is that the legislature instead created an optional program for the counties, but then provided additional dollars as an incentive to the counties to do it. What we're hearing is that many of the counties are considering it, however.
Great, thank you. So I did have somebody that just wrote in with a clarification of the partial custody issue for AB 2668. The bill actually says when the child of a non-minor dependent parent is not subject to the jurisdiction of the dependency court, but is in the full or partial custody of the non-minor dependent, and it goes on to talk about what's available. So it looks like the bill actually does include specific language that allows for this parenting plan, the parenting support plan, and the additional payment to be available to a non-minor dependent who has partial custody of their child. So thank you for that clarification. Another question on 2668, which is when this goes into effect. So David, do you know when this bill?
It's supposed to take effect January 1st.
January 1st, great.
Yeah.
And then, Amy, I'm going to give one last question to you on SB 1023. Does the bill provide any information about how the money gets distributed to colleges? Is it proportionate, or is there any sort of set limit that would be given to any particular district?
It does not specify that. Again, that is a process that the Chancellor's Office will determine whether it's a kind of a per student average. We did work closely with the Chancellor's Office to develop some financial estimates, surveyed programs that were serving foster youth to understand what is the staffing impact, how much more staffing does this kind of program require, what kind of material support do foster youth and community college require. And so they've done a lot of that thinking, and I would expect would draw from that, but that is in the statute.
Great. So one final question that came in, Susanna, which is, you had mentioned that the budget bill includes tracking of caseloads for counties. And there's a question as to whether or not you know, is there any sort of standard that's been set as to what a reasonable caseload is supposed to be for county social workers? Or is at this point they're just going to, go ahead.
There is a report that is now several years old that set kind of what the maximum caseload for a social worker should be. Many folks think that given some of the changes in the systems and things that may not be a valid number any longer. But there was some research done several years ago, and the legislature actually adopted a bill that set a reasonable caseload. I do not know, however, and this bill doesn't address whether the state will actually set that limit. All this bill does is start the process by making sure we actually even know what caseloads are currently.
Great. So I think those are all the questions that we have time for today. I want to thank everybody for submitting all of these great questions. We tried to whip through as many as possible and get that covered. Susanna, somebody's asking, do you know where they would find this report that you referenced, or do you know the name of it?
Can someone else on the phone help me out? I forget the name of the bill where the legislature set this. It was several years ago.
This is Amy. It's a report done by the Bill's UC Davis, and I think I have it. And it was done once, and then it was revalidated. And so if I don't have it, I'll track it down, and we can include it with the materials that are sent out to the group.
Great. So again, I want to give a huge, huge thank you to all of our panelists today for all of the great information. Thank you to all of you who have been listening and submitting your great questions. And you can watch your email for the slides. And again, it will be up by the end of the week on the California College Pathways website. And that concludes this morning's web seminar.